Hello, Mr. Chairman.
Mm-hmm.
This is Jim. I missed the invite to this corporation meeting. Where would I find that normally or in the future?
I will make sure to better email them out and ensure it should have been emailed from LSO last week as a calendar request.
Okay, thank you.
Yep. So with that
Mr. Chairman,
committee,
you're live on YouTube.
welcome to corporations. First order of business is to call the roll. Ms. Creech, I assume you'll have the roll in front of you.
Yes, Mr. Chairman.
Please proceed.
Representative Blackburn,
Here.
Representative Clausen,
Here.
Representative Clifford,
Here.
Representative Duncan. Here. Representative Ayer,
Here.
Representative Hunt,
Here.
Representative McGuire,
Here.
Representative Roscoe.
Here.
Chairman Zwanitzer,
Here.
you have a quorum.
Excellent. Well, committee, we're running a little behind today, as I think you all know. First bill up today will be Senate File 29, the revised Uniform Law Notarial Acts. Ms. Creech, if you would let in the Secretary of State's office. And maybe, I think there's a couple other people in the waiting room we'll ask at the appropriate time if they have comments. I assume
Mr. Chairman, I've made you a co-host and you can allow people in. And if you could remind people to raise their blue hand if they'd like to be let in, that would be fantastic.
I will certainly do so. So with that, we're going to bring in the Secretary of State's office. Good afternoon. I think it looks like Ms. James is joining us and is going to present the bill to us apparently. Welcome, Kelly. So we're on Senate File 29, and if you wouldn't mind walking us through the bill, we're a little behind schedule. So I know 5 of us were on the interim committee and 3 of the other members have talked to me over the weekend after they've read the bill. So you can go pretty cursory and I think we're on the same page.
Okay. Good afternoon, Mr. Chairman. Kelly James, Compliance Division Director, Wyoming Secretary of State's Office. I have with me today Carissa Corsi. She is our notary officer. And thank you so much for hearing this bill, and thank you to the committee members who were there during the interim working with this bill as well. I will give you the higher level version. Please stop me if you have questions. Currently, our notary laws are found in 2 different titles, and we have wanted to bring revisions for a while. We were going to originally bring them to you in this interim 2021, but with the pandemic, our office did issue guidance on remote online notarization, and to make those notarizations permanent, we do need to revise our law. There's also revisions to the uniform law. We do have uniform notary laws, but those have been revised as well. And so we also have some commissioning processes, other efficiencies. I just want to make sure the committee knows traditional notaries will always still occur. Paper notaries, these remote notarizations that we're adding to the bill are just another mechanism for notarizations that can occur if need be. The bill does create efficiencies, particularly for our notaries, and it provides these additional mechanisms such as remote online notarizations and remote ink notarizations, which we refer to as RON and RIN. There's new language to protect the notary and the public by allowing our office to take action if we have to deny or refuse a commission. There's also language regarding requiring a journal, and many answers that we get were answered into this bill. Many questions that we get, were answered in this bill in the language, the questions that we get from our notaries to clear that up. And it also gives us rule writing authority. Throughout the last year, our office worked with many stakeholders to bring you this bill. They included the Wyoming Bankers Association, the County Clerks Association, the Wyoming Realtors, Bankers Association, Land and Title, and the Association of Wyoming Insurance Agents, along with the bar. So I can walk you through the bill now if you're ready.
Seeing no questions from the committee at this time, we believe we're ready.
Perfect. Mr. Chairman, on page 2, section 101 is just our short title, Wyoming Revised Uniform Law on Notarial Acts. Section 102 is our definitions, and we have put quite a few new definitions into the bill just to make it more clear for our notaries and our public. A lot of these came from the uniform law, and a lot of them come from the new remote notarial acts as well. I'll start with on page 5, line 13, section 10 there is the electronic notarization system, and it is a specific form of communication technology. So just want to bring to the attention of the committee that this is a RON platform, an electronic notarization system, but hearing from our stakeholders, they wanted other ways to be able to perform the remote online notarization. So this is just one specific form that can be used. When we issued our guidance, we did get a lot of feedback that the platforms can be expensive and hard to use. So as long as we have an audio visual simultaneous recording in place, then that RON can be performed. And so that's just defined there. I'll bring your attention next to page 7. We're talking about identity proofing. And this is where you'll see on line 8 in the Senate, there was some questions about biometric data. And what that is just it's future proofing, just as now your tablet or your smartphone, you use your thumbprint or you do facial recognition, that is just in there for that. We defined on page 8, we defined jurisdiction, and later we defined venue, because those were just questions that come up when the notary is performing their act. I'll flip you over to page 11, and this is where the remote ink notarization and remote online notarization are defined. A remote ink notarization is for an acknowledgement only. It would be where a notary has the principal sign the document, then it is sent over to be notarized in a different area. The RON, however, the remote online, is a simultaneous video audio notarization where the act occurs in one place. Satisfactory evidence has just been explained for all notarial acts. Satisfactory evidence has to be met. Again, we define venue on page 15. Section 103 is just applicability. Section 104 is the authority to perform the notarial acts. And I'll just draw your attention to lines 14 through 16 of section B. And that is just that a notary can now notarize in any of our bordering states, as long as that bordering state recognizes our authority. So a Wyoming notary could go to Montana, to Nebraska, to Colorado to notarize if they can.
Do all 7 states recognize our authority? Do you know off the top of your head?
3. Oh, Mr. Chairman, 3 states do currently.
Thank you. Good.
Section 105 is notarial acts in this state, and this is all current language that we already have. 106 is also in another state, same current language that we have. 107, this is new language. This is uniform from Rulona, and that is the federally recognized Indian tribe. And Rulona is just the acronym for the Revised Uniform Law on Notarial Acts, Rulona. So this is all new, recognizing for the Indian tribe language. 108 is federal authority. Again, that's already in our current law. 109, Foreign Notarial Act. And right after 109, we do have a section for our certificate of authentication. These are our apostilles and these are our apostilles. And I'll just draw your attention to line 17. The fee here was doubled. It was $10 per apostille. And these are your documents that we get that need to go overseas. So if there's an adoption that occurs, or a student that comes to Wyoming to be at the University of Wyoming, that we have to authenticate these documents and send them overseas when they need them. So this $20 is just on par with other states.
Ms. James, didn't we just raise that fee about 3 years ago when we redid the apostille statutes?
Mr. Chairman, yes, that's correct. We did not have any laws allowing us to perform these, and so we did bring you that. At the time, we could only charge $3, because it was just that we didn't have any language anywhere. So it went from $3 to $10, and we looked at what other states are doing, and $20 is more on par.
Okay, go ahead.
Also on page 25, the language at the top of the page, line 1 through 15, this is all new language, and it gives us the authority to reject an apostille when we need to, when they come from sovereign citizens or claiming that the state owes them millions of dollars or something like that. Section 111 is requirements for certain notarial acts, and this is all standard language. On page 28, it starts the explanation of the remote notarial acts, the RON and the RIN under section J. And that goes through page 29, 30, 31, all the way through the end of that section. Section 112 is the authority to refuse. And this is some new language for the notaries to help protect them. You'll see on the top of page 33, it gives the notary the ability to refuse if they're not satisfied with the electronic system, or if they don't know how to operate it, then they can refuse to do it. 113, if the principal is unable to sign, and this is all standard language that we have already in our law. 114 is a certificate of the notarial act. And I believe this is all the same. Then we have 115, which is our short form certificates, and these are almost identical to what we have in our current statute. Over to 116 is our official stamp and signature and stamp. And these just added provisions for the electronic stamp. On page 46, we add an identification number to the Notary Commission, and that is just to help prevent fraud. 117 is your stamping devices. And 118 is your audio visual recordings and journal. In committee, Mr. Chairman, the draft bill did have language what is required in that journal and how long you have to keep that journal. And all of that language was deleted. You still have to have a journal, but now it gives the flexibility for the notary to decide how, or the employer. We do plan to address some of that in best practices in education. Section 119 is acceptance of the tangible copy of the electronic record, that the recorder may accept those. 120 is your commission process, and this is really where it has been streamlined. First of all, I'll draw your attention to lines 18 through 20. We are now allowing for a non-resident of the state of Wyoming to become a Wyoming notary if they work in Wyoming. We do have a lot of people that live in the state of Idaho and work in Jackson, and now they would be able to become a Wyoming notary, or if you have a spouse or a legal dependent of military personnel. On page 53, it does talk a little bit also about an education requirement. This is where, in our current language, the bond was removed. In our draft bill, we did have a bond of $10,000. Currently, it's $500 notary bond. We bumped that up to $10,000, and it was removed completely, which is about what half of the other states do as well. Some states do have a bond, but some states completely remove it. So there is language later in the bill that allows for a notary to always get their own surety bond and their errors and omissions, but it's not required in statute any longer. So this has changed the process from 9 steps, from getting the commission through our office, getting the bond, filing the bond with the clerk, getting the certificate, to now 3 steps. So from 9 steps to 3 steps, our notary public can become commissioned. At the bottom of page 53, you'll see that there's a filing fee of $60. We are increasing this fee, but we are also increasing the term of a notary, and we're removing the bond payment and the recording fee. So the notary will actually pay less. Previously, it is, well, currently, sorry, for a 4-year term, you pay the $30 commission fee, $50 for bond premium, and $18 for the recording fee. So $98 for 4 years. We're now going to $60 for 6 years. So the notary will actually pay less. The next section is 121. This is the examination education. This was requested by notary publics, and it will be a huge benefit to them if they want to have this education and this exam requirement. 122 is our grounds to deny, refuse, renew. We don't currently have the ability to do this, so this is great when we need to be able to revoke a notary.
Hey, Ms. Janes, if I could stop you real quick. Do you already have a course that you have developed, or are you planning on contracting that out?
Mr. Chairman, we do not have one. We are actually hoping to develop one internally. We do have an education coordinator that will assist with that. And so that is something we'll be working on in the next few months. And we do have the ability to contract that out. I believe there's language in here that we can, but our plan right now is to do it in-house.
And you're not asking for any funding to do that?
That's correct, Mr. Chairman. We would like to ask for funding, but we did not. Correct.
Appreciate it. Okay, go ahead.
Mr. Chairman, I believe we're on section 123, which is our prohibited acts and penalties. The language in here is Rulona. It is uniform language where the notary officer's spouse or civil partner, they cannot notarize their spouse's signature. This is not in statute now. It's always something that we have told people that they should not do, but now it is in statute that they cannot. The next section is 124, validity, and 125 is rulemaking authority. We don't have any rulemaking authority currently in notary statutes, so this is nice that we'll be able to have that when we need it. Fees are 126. Currently, a notary can charge $5 per notarial act, and this has been changed to $10, again, just to be standard with other states. They are also able to collect for the technology fee, which is on page 66. That was one of the complaints we heard about using the remote notaries, is that they weren't able to collect a separate fee and they were very expensive. And then, of course, a travel fee, which is also in our current language. Section 127 is how to change your name or contact information. Section 129, this is transition language on current notaries into how the new notary term will work. 129 savings clause, 130 and 131 are complying language. And then we get into section 2, which is your just any language where it references our notarial laws to clean up throughout statutes. And the bill will become effective July 1st of 2021. So with that, I'll stand for any questions.
All right, thanks. Before I get to Representative Hunt, the Senate did have a standing committee amendment where they changed that fee from $30 to $60 on page 73. Was that a request of your office, or any elucidation on where that amendment to double the price came from?
Yes, Mr. Chairman, that was at our request. That was just some cleanup language that we found prior to the committee meeting, and it was just a typo. That is actually under our Title IX, which is the duties of the Secretary of State, and it talks about how the Secretary shall collect. And we had in there $50, and it should have been $60.
Okay, and all of these fees go to the general fund still?
Yeah, that's correct.
Okay, Representative Hunt, question.
Thank you, Mr. Chairman. Going back quick to 3-120, and you mentioned allowing provisions for those who do not live in Wyoming to be qualified, using the example of living next door in Idaho. But I guess what I'm wondering is what about in the case of remote working? I mean, are we opening this up to the entire country if you live anywhere within the U.S.? And if so, are the standards and qualifications and so on and so forth more or less uniform across the country? Or am I splitting hairs there?
Ms. Janes, go ahead.
Mr. Chairman, Representative Hunt, a physical notary, we could open up to the bordering states. So if you're going to do your traditional notary where you would go to a bordering state, you can perform that as long as they recognize that. The remote notarizations are opened up to, as long as that notary is a Wyoming notary, has notified our office that they're going to be doing remote notarizations, then that is opened up to the whole world. Yes, and to answer your question regarding the standards, there is very standard language on RON, which is in the Uniform Act. We have opened it up to more than just a platform, as long as you have that simultaneous audio-visual recording and you meet all the requirements, satisfactory evidence, all of that, then you can perform that RON.
All right. Other questions from the committee? Representative McGuire.
Thank you, Mr. Chairman. I was wondering if you could please describe for me physically how it would work. So if I were on the chairman's yacht down in the Gulf of Mexico, still within the territorial waters of the United States, and I wanted to sell my car to him, which is an old junker car, by the way, but I have my physical title with me, how would that actually work electronically? Could you please describe how the process would work? Thank you.
Ms. James.
Mr. Chairman, I'm going to have our notary officer answer that one for you.
Great.
Mr. Chairman, Representative McGuire, if you are doing a remote notarization outside of the state of Wyoming, you could utilize a platform such as notarize.com, where you would upload your document to notarize.com for, I believe, about a $25 fee. You have some different options here. So notarize.com, as part of their service, would then provide a notary that could be commissioned in any state, not just Wyoming. So the notary would then gather the parties. You would be on the water, and the document would be electronic. The notary could be anywhere, like I said, could be Texas. They would initiate the electronic notarization, sign your documents electronically, and you would be done. Does that answer your question?
Reverend McGuire, follow up.
Thank you, Mr. Chairman. So then my question is, do I tear up the title and the title to that vehicle is now in electronic form only? My question is, how do we keep the chain of ownership, so to speak, on that one particular piece of paper, or do you have to have it reissued?
Go ahead.
Mr. Chairman, it would depend on how the recorder would want you to file that. So you might still need to have a hard paper copy, depending on how the county clerk's office is going to request that be filed. So for some scenarios, it might not be still electronic. You would still have to have that paper record, even though you did have an electronic notary on it.
Follow up one more time, Mr. McGuire. Representative McGuire.
Actually, I'd move on to a second question, if I may, Mr. Chairman.
Sure. And
I apologize, the copy that I'm looking at, I don't have page numbers, so I'm looking at 32.3.111 and subsection H. And I'm just wondering, is that a change? And again, this is sort of my recollection from years ago. I thought that as a notary, you were not allowed to notarize any document that came within your own corporation. Is this a change to expand that and do away with that old prohibition?
In committee, that's on page 28, line 6. Go ahead, Ms. James.
Mr. Chairman, this is identical language to what we have in law right now.
Okay. Thank you, Mr. Chairman.
Thank you. Other questions, committee? Seeing none at this time, let's check the waiting room. If you're in the waiting room and you wish to speak on this bill, if you would raise your hand. 15 people are in there, and I'm not seeing a single hand on notarial acts. Going once, going twice. Okay, we will close public comment on Senate File Oh, shoot, what are we on? Senate File 29. Committee, what's your pleasure?
Move the bill, Mr. Chairman.
Moved by Representative Hunt, seconded by Representative Clausen. Discussion on the bill, committee. I know 5 of you had the whole interim to enjoy. I'm not seeing any further discussion or questions from the committee on any part of the bill. So I'm waiting on someone to call for the question. Representative Duncan has called for the question and still seeing no further debate. Ms. Creech, if you'd call the roll on Senate File 29.
Mr. Chairman, this is a roll call vote on Senate File 29. Representative Blackburn.
Aye.
Representative Clausen.
Aye.
Representative Clifford.
Aye.
Representative Duncan.
Aye.
Representative Ayer.
Aye.
Representative Hunt.
Aye.
Representative McGuire.
Aye.
Representative Roscoe.
Aye.
Chairman Zwanitzer.
Aye.
9 ayes.
Okay, committee, while I have you, is anyone feel ambitious enough to want to floor manage this bill? Well, if anyone feels so inclined, please let me know. Otherwise, I'll plan on taking it, which means there's a couple more up for grabs today. Thank you again, Ms. Jane, Secretary of State's office. Always a pleasure to see you. Enjoy the rest.
Chairman, I can take that one if you would like. It's pretty simple.
I love it when people say 74-page bills are pretty simple. Great, Representative Duncan, it is yours. I'm sure
Thank
you'll
you,
meet.
Chairman, can I request before they take off, the Secretary of State's office, please send me their line by line highlights, please?
Mr. Chairman, Representative Duncan, absolutely.
Thank you much, Ms. James. Thank you. All right, committee, next up today will be Senate File 14. I'm just guessing that Ms. Johnson was the person I should be calling on in the waiting room. Welcome, Deputy Director Johnson. Since I was Chair of Corporations, you've been promoted. So welcome to your new role. Would I be correct in assuming you're presenting the bill?
Mr. Chairman, that is correct. We also have Commissioner Rude on the line as well.
I will bring him in as well. I suppose we could have the insurance commissioner here. All right, the floor is yours, or if you'd like to have Mr. Rude kick it off, whatever works best for you.
Oh, thank you, Mr. Chairman. This is Jeff Rude from the Department of Insurance. With me next door, literally, is Ms. Johnson, who will be presenting the bill. This is a credit for reinsurance bill. It's an update to a model act, which actually was passed a few years ago. And Ms. Johnson will explain it to you and hopefully answer any questions that you may have.
All right. Saying that, please proceed, Ms. Johnson.
Okay, thank you, Mr. Chairman. Again, my name is Linda Johnson. I'm the Deputy Commissioner with the Insurance Department. And the bill you have in front of you is Senate File 14. And this bill updates Chapter 5 of the Insurance Code, which relates to credit for reinsurance. And this is a law that's been on the books for a long time. However, we did update it back in 2017. And now we're requesting that it be updated again due to international developments and also in order to avoid federal preemption. In addition, this model law is a National Association of Insurance Commissioners accreditation standard that the department will need to have in order to maintain our accreditation with the NEIC, which we've held since 1993. And if you don't mind, Mr. Chairman, I can give you a little background about the bill and how we got here, and then I can do the 30,000 feet version through the bill. Is that okay?
Perfectly acceptable.
Okay, so just a little bit of background. I wanted to explain what reinsurance is. Reinsurance is insurance for insurance companies. You and I as policyholders don't deal with reinsurance. This is something that happens in the background, but this is, it's basically an insurance company passing off risk to another insurance company called a reinsurer or an assuming insurer. And so it allows the insurance company to reduce the liabilities it reports on its balance sheet because it's ceding off some of that risk to another reinsurer or multiple reinsurers, provided those reinsurers meet certain requirements. And the reinsurance framework that we currently have in Chapter 5 provides 6 different ways that a domestic insurance company can reduce its liabilities on its balance sheet by utilizing reinsurance. So this bill adds a seventh way that a domestic insurer can qualify to reduce its liabilities on its balance sheet, providing that it's using reinsurers that meet certain requirements that are specified in this bill. So in the past, we used to require offshore reinsurance companies to post 100% collateral for any risks that they assumed from US insurance companies. And this became an international trade issue because a lot of the world's largest reinsurers are located across the Atlantic. So your Lloyd's of London, Munich Re, Swiss Re, those companies. So back in January and February of 2017, you may recall that we updated this law to allow those offshore reinsurers an avenue to be able to reduce that collateral that they had to post by meeting certain requirements. They could become a certified reinsurer, and as long as they were domiciled in a qualified jurisdiction, they could qualify to reduce the collateral that they post from 100% to say 10% or 20%, or even 0%, provided they met certain requirements. So that's what happened in early 2017. And then fast forward to September of 2017, and this is when the US Trade Representative signed a covered agreement with the European Union that eliminated all collateral requirements for EU companies, provided they meet certain requirements. And then in December of 2018, the US Trade Representative signed a similar agreement with the UK, which mirrors the EU agreement. So based on these agreements, state insurance regulators now have 5 years from the date that covered agreement was signed with the EU in order to come into compliance with its terms, or else we face federal preemption starting in September 2022. So that's why we have another update to this law in order to avoid federal preemption. So in this bill, we're introducing the concept of reciprocal jurisdiction, and this will allow reinsurers that are domiciled in those jurisdictions to not have to post any collateral for any US risks that they assume, provided they meet certain requirements. And so with that as a little bit of background, I'll start going through the bill. So on page 1, section 1, we're adding several new paragraphs here. And on line 14 of page 1 in section 112, we're updating section 112 to include Roman numeral 7, which starts on page 2, line 20. So again, we're adding a 7th way to allow a ceding insurer to take credit for reinsurance and reduce the liabilities it reports on its balance sheet when the reinsurance is ceding to an assuming insurer that has its head office or is domiciled in a reciprocal jurisdiction and is licensed in a reciprocal jurisdiction. So I'm on the top of page 3 now, and we do define reciprocal jurisdiction later in the bill on page 12, but reciprocal jurisdiction would be one of those jurisdictions that has signed a covered agreement with the US. So right now, the UK and the EU. And so on line 5 of page 3, the assuming insurer has and maintains minimum capital and surplus specified in rules adopted by the commissioner. So with this bill, we would have to update chapter 50 of our existing rules to include a $250 million requirement for capital and surplus for these assuming insurers. So these are, again, your large companies, not your fly-by-night outfits. And then on line 18 of page 3, the assuming insurer has and maintains a minimum solvency or capital ratio as specified in rules adopted by the commissioner. And again, we have to update chapter 50 of our rules, but this would require a 300% risk-based capital ratio or a ratio that's used in that company's domiciliary jurisdiction. So again, these companies have to be well capitalized in order for the ceding insurer to take credit on its balance sheet for ceding liabilities to these companies. On page 4, line 6, the assuming insurer also has to agree in writing to the following 5 requirements, and these are spelled out on the next few pages. The first one is on line 10 of page 4. The assuming insurer shall provide prompt written notice to the commissioner if it falls below the minimum capitalization requirements, or if any regulatory action is taken for serious non-compliance. And then the second item that the assuming insurer has to agree to in writing is they shall consent in writing to the jurisdiction of the courts of this state and to the appointment of the commissioner as agent for service of process. And if you go over to page 5, line 6, The third item that they have to agree to in writing is they shall consent in writing to pay all final judgments wherever enforcement is sought, obtained by a ceding insurer. And then the fourth item on line 12 is each reinsurance agreement shall require the assuming insurer to provide security equal to 100% of the assuming insurer's liabilities if the assuming insurer resists enforcement of a final judgment. So again, a good consumer protection there. And then over on page 6, the final item that they have to agree to in writing is the assuming insurer shall confirm that it is not presently participating in any solvent scheme of arrangement which involves this state's ceding insurers. And a solvent scheme of arrangement is a UK mechanism. It is not beneficial to policyholders. So that's why this provision is in there, that if the assuming insurer is participating in one of those schemes, they have to agree to post 100% collateral again. And then if you go to line 13 on page 6, it says the assuming insurer shall provide documentation to the commissioner as specified by rule. And then on line 19 of page 6, it says the assuming insurer shall maintain a practice of prompt payment of claims under its reinsurance agreements. And if you go over to page 7, line 1, the assuming insurer's supervisory authority, regulator, shall confirm to the commissioner on an annual basis that the assuming insurer complies with the capitalization requirements on page 3 of the bill. And then down on line 13 of page 7, the commissioner shall timely create and publish a list of reciprocal jurisdictions. We currently have a list of qualified jurisdictions on our website from the 2017 legislation. So providing this list on our website of reciprocal jurisdictions is manageable. We'd be able to do that. And then on page 8, on line 14, says the commissioner shall timely create and publish a list of assuming insurers that have satisfied all conditions and to which cessions shall be granted credit. And again, on our website, we currently have a list of certified reinsurers based on the 2017 legislation. So again, we could update our website to include these reinsurers as well that meet these requirements. And if you go over to page 9, line 5, if the commissioner determines that an assuming insurer no longer meets one or more of the requirements, the commissioner may revoke or suspend the eligibility of the assuming insurer as set forth in rules. And then going over to page 10, line 4, if subject to rehabilitation, liquidation, or conservation, the ceding insurer may obtain an order requiring that the assuming insurer post security for all outstanding ceded liabilities. Again, a good protection there. Sometimes when an insurance company is having financial trouble, it's hard to get the reinsurers to pay. So that's an important provision here. And then on line 19 of page 10, it says credit may be taken under this paragraph only for reinsurance agreements entered into, amended, or renewed on or after July 1, 2021, which is the proposed effective date of this legislation, and providing that the assuming insurer has met all eligibility requirements. So again, this would not be in effect for agreements that are currently in effect. They would have to be entered into, amended, or renewed on or after July 1, 2021. So any collateral requirements that are currently in place under those agreements would remain in place. And then skipping over to page 11, line 21, this is where we're adding some definitions here. And on line 21, we're defining covered agreement, which means an agreement entered into pursuant to the Dodd-Frank Act and that addresses the elimination under specified conditions of collateral requirements. And then on line 8 of page 12, we're defining reciprocal jurisdictions. And there's 3 ways you can meet the definition of a reciprocal jurisdiction. The first one is on line 11. You can be a non-United States jurisdiction that is subject to an in-force covered agreement with the United States. So again, the EU and the UK would meet that definition. Or on line 17, you could be a United States jurisdiction that meets the requirements for accreditation. And then on line 21, you could be a qualified jurisdiction, which is again that language we adopted in 2017. But you'd be a qualified jurisdiction that meets certain additional requirements consistent with the covered agreements. So 3 ways to be a reciprocal jurisdiction. And then on page 13, line 6, section 116 deals with our rules. And again, we will need to update our existing rule in Chapter 50 for the provisions of this legislation. And then on line 20 of page 13, we're just renumbering existing language here, and same on page 14, line 2, we're renumbering existing language. And on page 14, line 16, this act is effective July 1, 2021, which would give us plenty of time before the federal preemption would kick in September of 2022. With that, I can answer hopefully any questions.
So would I be correct, Ms. Johnson, that this is all model language from the NAIC, and I don't see anything specific to Wyoming, what we used to call home cooking as part of this act? It's boilerplate, 100% language to keep us in compliance with the other states. Would that be correct?
Mr. Chairman, and even in the bigger picture, to keep us in compliance with the global community. So not only the NEIC, regulators discussed this language, but it also had input from the global community as well. So when we were developing this model law, it was impressed upon us that it's important we stick with the script, because we could face federal preemption if somebody interprets our law to be different than what was intended under those covered agreements.
I like how the Department of Insurance is the one agency who can legitimately say, do not dare amend bills we have or face global ire. So I probably won't be expecting any amendments from the committee. Representative Hunt, do you have a question?
Mr. Chairman, thank you. Just real quick, and I apologize, I'm being new to the committee, I'm kind of new to the issues, but when we're talking about reinsurance companies, are those companies, is that just what they do, is insure insurance companies, or are we talking about more of an exchange in which here's a regular insurance company, but on the side it also will buy off risk from another insurance company so that they sort of trade that out? How exactly does that work?
Ms. Johnson, go ahead.
Mr. Chairman, Representative Hunt, that's a very good question. Actually, reinsurance companies can write insurance as well as reinsure. So they can do both, or they can just be professional reinsurers. So.
Okay, further questions for Ms. Johnson? Representative Ayer, go ahead.
Thank you, Mr. Chairman. I think when you're talking about the requirements that they have to immediately report to the commissioner regarding if they fall under the capitalization requirements or if they face issues of insolvency, is there any way that we check up on them if they don't report any of those events?
Ms. Johnson, do we do any of that in Wyoming?
Mr. Chairman, that's a good question. Under the current provisions we have for certified reinsurers, that is an annual application that they make, and then it's renewed every year. So there will be a process to check on those companies. Yes.
Okay. Further questions for Ms. Johnson? Representative Ayer, go again.
Well, one more follow-up, and I know the answer to this, and it's pretty intuitive, but could you just give us a simple explanation of how this benefits people being insured in Wyoming?
Sure, go ahead, Ms. Johnson.
Okay, thank you, Mr. Chairman. So we do have a property and casualty insurance company that does use offshore reinsurers. So I believe this will help them obtain reinsurance, hopefully at maybe a lower cost, because those companies will not have to tie up their capital in collateral that they used to have to post. In addition, it can help the consumer if you look at it from the ways of, if you have, say you have a $10 million home. I'll just use kind of an example of reinsurance. Say you have a $10 million home and you come to me, I'm a small insurance company, and I can't afford to take on your $10 million home because I'm very small, and a total loss on your home would wipe me out as an insurance company. So I can partner with the reinsurer to share the risk, and then I can write your policy. Now, when you pay me the premium for that policy, I'm going to have to share that premium with the reinsurer because they're not going to do this for free. But then if you have a total loss on your $10 million home, I may only have to pay $1 million of that, and the reinsurer will reimburse me $9 million to kind of help me share in that risk so that I can write your policy. And then you have the protection of the reinsurer, even though you won't deal with the reinsurer directly. That'll be me dealing with the reinsurer, but you will be able to have that insurance knowing that there's a larger company backing me and should be able to pay your claim should you have a total loss. I don't know if that explains that very well, but yeah. Okay.
Yeah, perfect.
Okay.
Mr. Chairman, just a quick follow-up on. So it would be safe to say that this would actually reduce the risk to our domestic consumers.
Ms. Johnson, is that fair to say?
Mr. Chairman, yeah, it could, like say, if most companies do reinsure, unless you're like a huge insurance company like State Farm, a lot of companies will reinsure just with the hail risk, hurricane risks. It's nice to be able to cede off some of that risk because unless you're, in the billions of dollars of capitalization, it's, those storms can be pretty expensive.
Okay. No further questions from Ms. Johnson. I'm not seeing. Hang tight, Linda, for a bit. We'll take some public comment. First up will be Ms. Lee. If you're in the waiting room and you have public comment on Senate File 14, please raise your hand and I'll pull you in one at a time. With that, welcome, Kristen, to Corporations.
Thank you, Mr. Chairman and members of the committee. My name is Kristen Lee, and I represent the American Council of Life Insurers, or ACLI, out of Washington, D.C. And ACLI supports this bill for 3 reasons. It's very good for domestic insurers in that they have access to reinsurance without strict collateral requirements. And the requirements also help the insurance department maintain its accreditation. And 3, this avoids preemption by the federal government. So my client, ACLI, supports Senate File 14. And thank you very much to Deputy Johnson, for explaining the bill so well. I'll stand for questions, but I'm sure I would have to send those questions to Deputy Johnson.
We'll see. Any questions from Ms. Lee? Seeing none, always a pleasure to see you in a different government affairs role, Ms. Lee, and super excited you represent ACLI.
Thank you, Mr. Chairman.
Yep.
It's good to have you back in corporations.
It's good to be here. All right, enjoy your day. It's good seeing you. Next up, Ms. Wilkinson. Welcome.
Thank you, Mr. Chairman, members of the committee. My name is Catherine Wilkinson, here today representing American and Property and Casualty Insurance Association. Mr. Chairman, we too stand in support of the bill. It's very important to all of the insurance companies across the state that the Wyoming Department of Insurance does maintain that accreditation. And so we stand in support and be happy to answer any questions.
All right, committee questions from Ms. Wilkinson. Seeing none currently. Thank you, Catherine. Always a pleasure as well. Next up, I think we have one more public comment, Mr. Hauk. We're going to bring him in real quick. It said I did. There he comes. Hi, Ken. Welcome to Corporations. We're on Senate File 14, and the floor is yours if you have any comments, Mr. Hauk. One more time. Ken, can you get in? There he comes. Hi. Oh, but you're on mute. See if that works. There you go.
Now, can you hear me?
Yep.
There we go. Thank you, Mr. Chairman and members of the committee. Appreciate the time to testify today. My name is Ken Hauk, and I'm the Executive Vice President of the Association of Wyoming Insurance Agents, also referred to as AWIA. AWIA. I've been a part of the insurance industry in numerous roles since the 70s, and I've been a part of AWIA since the 80s as a member, as a board member, and as the executive vice president on 2 occasions. The little background on our association, because we are not an insurance company as the other people who have testified are. AWIA is comprised of independent insurance agents who provide property and liability insurance as well as life and health insurance to their clients. So we utilize the companies that the other members have testified, or the other testimonies come from. Our members each represent many insurance companies. Most represent 20 to over 100 at times. Our membership includes about 300 licensed insurance agents in Wyoming and 83 different offices in Wyoming with 20 different ownership groups in Wyoming. Their business names are their brands. They're bona fide entrepreneurs. You'll see numerous insurance company brands if you walk into one of their offices or go onto their website. And you'll see names like Liberty Mutual, Safeco, Acuity, Travelers, Progressive, EMC, MetLife, Hartford, Grange, Nationwide, and many, many others. So you don't confuse us with others in the state. There are other types of property and liability insurance agents operating in Wyoming under different formats. Some are direct writers, meaning they are direct employees of an insurance company, and you'll see their brand, their company brand, prominently displayed. Notably in Wyoming, that would probably be Geico and USAA as an example. There are other agents who operate as captive agents in Wyoming, and meaning they are local business entrepreneurs, but they generally represent only one company, and you'll see that company brand prominently displayed. Again, most notably, it'd be State Farm, Farmers Insurance, Allstate, and Farm Bureau. So just to be clear, we never speak for the direct or the captive agents. Since so many of you are new to this committee, our roots go back to 1933 under numerous different names. We belong to 2 national associations, primarily because they allow us to have an advocacy voice in Washington, D.C. Some of you will know us from the famous Shrimp Bash, which we have held every year for the last 40 years. And hopefully we get to do that again this year. Now to the subject at hand. You know, in your tenure on this committee, and this is maybe a little bit redundant, but you've heard the term accreditation, you've heard the term National Association of Insurance Commissioners, or the NAIC. And you know, in the past, I've heard some people be confused that think that's a federal thing, but it's not. It's the National Association of the 50 Insurance Commissioners. Go to NAIC.org and you can get a lot of insurance information for yourselves as you research things and become a more active member of this committee. But you'll notice model acts, and that's been referred to today. And a model act is extremely important for the 2 reasons that were mentioned today. But the purpose is really to pass those laws that are very common for all of the states, but still allow the state to have its own laws that are applicable strictly to the state. We do not want federal preemption, as has been mentioned a couple of times. For your information, there is a federal insurance office, and they're waiting to take over if the states drop the ball. So we want to keep the regulation in the state of Wyoming, and we do want to keep the premium taxes in Wyoming, which if you've looked at your budget, you'll probably see that's pretty significant. So regarding model acts and accreditation, at all times, AWIA will always be supportive of the Wyoming Department of Insurance. Again, we would prefer that tax revenue stay in Wyoming, and we prefer the regulations stay in Wyoming. So we support the passage of SS 14, credit for reinsurance. And on a side note, some of you know Dave Euchner, and Dave Euchner is no longer with us, but many of you knew him. He often said that the leadership of the Wyoming Department of Insurance at the present time is as good as it's ever been. And I have had a working relationship with the DOI going back to the early 80s. I've known most of the commissioners, some very well. And I would agree with Dave's assertion that the quality of leadership of the DOI today is as good as it's ever been. They do promote an open door for discussion and collaboration on industry topics, and we appreciate that. Thank you, Mr. Chairman. I stand for any questions, but I doubt that you'll have any.
Thank you, Ken. And thanks for those comments on the Department of Insurance. 14 years around here, it's as good as it's been, I would agree. Questions from the committee? Seeing none, thank you very much today. Enjoy your Monday. Committee, let me see if there's any other public comment on Senate File 14 in the lobby. Raise your hand if you're in the lobby on Senate File 14. If you are here for the net metering bill, we are not hearing that today, so no reason to hang out with us. We're going to move net metering back to March for an in-person hearing. But seeing no other public comment in the lobby on Senate File 14, committee, what is your pleasure?
Move the bill, Mr. Chairman.
Moved by Blackburn, seconded by Hunt. I saw his hand first. Is there any questions, committee discussion, or amendments that you don't want to bring on a uniform bill? I'm not seeing any, and sensing you're ready for the question.
Question.
Thank you, Representative Bear. Ms. Creech, if you'd call the roll on Senate File 14.
Mr. Chairman, this is a roll call vote on Senate File 14. Representative Blackburn.
Aye.
Representative Clausen.
Aye.
Representative Clifford,
Aye.
Representative Duncan,
Aye.
Representative Ayre,
Aye.
Representative Hunt,
Aye.
Representative McGuire,
Aye.
Representative Roscoe,
Aye.
Chairman Zwanitzer.
Aye.
9 ayes, Mr. Chairman.
Well, congratulations, Mr. Rude and Ms. Johnson on 9 aye votes. Committee, anybody want to floor manage this one? I'm certainly happy to do. Representative Clifford, you want it? It is all yours. I'm sure Ms. Johnson and Mr. Rude will send you any talking points and I'll be happy to help. Excellent. All right, committee, I know we only have about 25 minutes left, but I would like to at least get some comment and testimony on Senate File 18, Universal Occupational Licensure. This was an interim bill from the committee, but I'm not sure, Representative Duncan or Representative Ayre, was it brought from a specific entity or agency? What I'm secretly asking is, do you know who I should call on to present the bill since I'm new?
Mr. Chairman, this was a bill by the former chairman, basically. It morphed into a, it was a constituent of his about a physical therapist who couldn't get his license. And then it morphed into military. And so it just kept shifting and morphing, and it happened to do with COVID. And so it ended up being a multiple of, kind of a snowball of a multiple of issues all into one. Is that your recollection, Representative Clausen?
I know, yeah, Representative Clausen, have your hand up. So I didn't call on you. You were just in the third row of my screen. Other comments?
Mr. Chairman, so this was a culmination of several licensure problems. I had a constituent with a problem as well, that COVID, the COVID rules wouldn't allow the licensing process to go through. So there was a need to adjust for some emergency rules and then some rules for military families, and it kind of all got wrapped into one. So a little bit of background, but it was more than just one occasion. There was a whole conglomeration of licensure problems from the COVID orders.
All right, committee. Well, I know 5 of you were in the interim, and I've talked to at least 2 of the other members regarding the bill. So I think we have a pretty good background and don't necessarily need to go line by line. And as well, there is an amendment, I think, from Representative Andrew at the proper time to switch up the bill a little bit. But until then, let me take some public comment. I know Representative Larson is here. Do you have any public comment on this bill to kick us off, Representative Larson?
Mr. Chairman, thank you. I actually brought the bill last year and almost got it through in the budget session, or at least to the floor. To the floor. And it had everything pretty much that this one had, but didn't include the military expedited stuff. And that has me worried that, I think the military personnel that come here, we're definitely in favor of them being in Cheyenne, but I'm not sure if they're needed to have any benefits. They should be just like the rest of the working people that may come to this state. So if you need anything else, let me know.
Okay. Representative Andrew, any kickoff questions or discussion on the bill, or are you here just to wait for your amendment?
I'll just speak on the amendment. Thank you, Mr. Chairman.
Okay. Well, we'll start doing some public Representative Clausen, go ahead.
Mr. Chairman, just a quick comment on the military portion. During the interim, we had quite a little bit of comment from the military themselves that this helped out in spouses, military spouses, and then there was a need. So that's where the military portion came from.
All right, good segue. First up for public comment will be Ms. Peralt from, I think, the Department of Defense. Welcome, Tammy. Give you a second to turn on your camera there. Hi, welcome to Corporations.
Good afternoon, Chairman Zonser and members of the committee. My name is Tammy Perot, and I represent the Department of Defense and Military Families in the Northwest. Thank you for the opportunity to provide public comment today on Senate File 18, Universal Occupational Licensure. This legislation provides expedited temporary licensure for military spouses that hold a relevant, active occupational or professional license in good standing from another state. And I am the Northwest Regional Liaison for the Defense State Liaison. We operate, just so you know, under the Secretary of Defense for Personnel and Readiness, essentially staff for the Pentagon. Licensure issues affect career portability for spouses of military service members. This has been a priority for the Department of Defense for several years to address these issues. And our military members and our families move from state to state, transferring their licenses in order to obtain employment at their new military assignment. This is often a challenge. It's important for their career sustainability and their family financial sustainability to pass legislation like this. Policies to enhance existing licensure provisions for military spouses serve to relieve one of the many stressors of frequent military moves. Wyoming is home to over 1,100 active duty spouses. 34% of those military spouses in the workforce are in licensed occupations, and currently 19 states have incorporated language to ensure military spouses can quickly obtain an occupational license based on licensure provisions in their previous state. We ask Wyoming consider this helpful policy language as well. In closing, we're grateful to the tremendous efforts Wyoming has historically made to support our military members and families. We appreciate the opportunity to support the policy reflected in Senate File 18. Thank you for considering this issue. I stand for questions.
Thank you, Ms. Perot. Are there questions? The Department of Defense. I'm not seeing any right now from the committee. I think we're letting you off easy, but certainly appreciate your testimony and for being with us this afternoon.
Thank you very much, Chairman.
Thank you. Mr. Steenbergen from the Cheyenne Chamber of Commerce. Thoughts on the bill? And Ms. Perot, we'll keep you in the room. I'm just going to turn off your video and don't go too far. With that, Mr. Steenbergen, welcome.
Mr. Chairman, thank you for the opportunity to comment on this. I might just tell you that middle of the year last year, we popped up on a Department of Defense kind of a board that they keep, and we popped up as a yellow. Wyoming has really done some nice work on this licensing over the years, but we did get behind just a tad, and this bill addresses that. Met with some of our leadership from here at Warren and on up to Global Strike as well, and we told them that we thought that the legislature would get on it and would turn us back to green on their judgment of Wyoming. So I appreciate you considering this bill and hope we can get it through and take good care of our military spouses here in Wyoming. Thank you, sir.
Let no one say that Wyoming is yellow. Are there any questions for Mr. Steenbergen? I'm not seeing any at this time. Thank you very much for being here, Dale. Always a pleasure to see you again. Ms. Urbicite from the Wyoming Association of Realtors. Welcome to Corporations.
Good morning, Mr. Chairman, members of the committee. Sorry about that. Get my screen fixed. Yes, I'm Lori Urbicite representing the Wyoming Realtors. We are supportive of this bill as written. We do understand there is an extensive amendment, and as long as that amendment includes language similar to what you will find on page 4, lines 2 through 6, requiring specific testing for Wyoming law. The real estate profession, the best example of why we think that we need specific Wyoming testing is our agency legislation, our agency laws. In Wyoming, we do not allow dual agency in a real estate transaction, meaning that you're representing both sides of the transaction. There are other states that do allow that, and that's a big no-no in Wyoming. We have a transaction broker, which is not the same meaning of transaction broker as in Colorado. Colorado has all broker licenses and not individual sales and responsible brokers. So there are a lot of different nuances in our Wyoming license law that we believe anybody practicing real estate in Wyoming with a Wyoming license should be familiar with and should abide by. So we are supportive of the bill the way it's written. And again, if the amendment has satisfactory language that will require the testing for Wyoming specific statutes before they can be licensed in Wyoming, we're okay with that as well. But we are supportive of the bill as written, and I'd be happy to answer any questions.
I feel like I put some of those statutes in place over the years. Are there questions for Mr. Urbicite? I'm not seeing any at this time, and I did send you a copy of the potential amendment, Ms. Urbicite. So if you have thoughts on it, jump back into the debate.
Okay, thank you.
You're welcome. Not seeing any questions. Let's bring in Ms. Somerville, former mayor of Laramie. Welcome, Andy.
Thank you, Mr. Chairman. Andy Somerville, Executive Director for WAMSAC, which is the Wyoming Association of Mental Health and Substance Abuse Centers. This is not a committee that I generally get to visit on a frequent basis, so I appreciate the time to visit with you guys. In general, just to keep it very brief, we are supportive of the bill as it's written. For mental health workforce, we want to encourage all of our military spouses that come into Wyoming to get to work as quickly as possible. We understand there's not any concerns from our area in terms of impact to the board, that they should be able to handle this in an expedited manner without any issues. I would reserve any comments on the amendment until we've heard a little bit more about it and the discussion. With that, I'd stand for any questions, Mr. Chairman.
Okay, questions for WAMSAC? Not seeing at this time. Thank you very much, Andy. Always a pleasure. And if you are in the waiting room and are one we brought in, please raise your hand. Next up, we're bringing in Mr. Smith. We'll give him a second to join in the conversation. Welcome, Chris. The floor is yours for comment.
Thank you, Mr. Chairman, members of the committee. I am Chris Smith, the Senior Counsel for the Wyoming Military Department. A couple of things to bring to the committee's attention. One historical note, back in 2013 in Senate File 74, we created 33-1-117, which allowed for the temporary practice permits to military spouses. And it's really worked fairly well. There have been a few glitches because in the existing statute, as you can see on page 7, it only lasted for 120 days, and there have been some times when that has caused some problems. So I think once more, this helps Wyoming continue to lead the way in assisting our military members. A second thing I wanted to bring out, we in the Wyoming National Guard sometimes bring people in from out of state on military orders, and this would help them and their spouses. So just so the committee understands, it isn't just an FE Warren active duty thing. This actually has some benefit to the Guard as well, although certainly not in the same numbers as FE Warren experiences. The third thing I wanted to bring out that I think Ms. Perot touched on is the DoD has at various times scored states based on veteran and family support. We heard about the yellow. This is one of the areas where they've looked at, and it does become a consideration as far as we understand with Department of Defense and particularly the U.S. Air Force in terms of their basing considerations. So we have enjoyed, in the military, have enjoyed incredible support from this legislature, and this bill as written certainly continues that support. And it looks like the various boards that this impact are totally supportive because they too have done everything they could do. With that, I stand for the committee's questions.
Question, Mr. Smith. Let's start with Representative Duncan, and then we'll go to Representative McGuire.
Thank you, Mr. Chairman. Mr. Smith, have you had a chance to look at this proposed amendment? You've been with us since the beginning, so I'm just curious as if you've seen this amendment or not.
I have it up, and I just pulled it up while the hearing started, and I haven't really reviewed it, ma'am. Mr. Chairman, excuse me. Representative Duncan.
Mr. Chairman.
Go ahead.
Thank you, Mr. Chairman. Mr. Smith, I would like you to weigh in again after you've had a chance to look over it. Since we've had this whole interim going through this back and forth, I'd just be curious as to if you, it's a lengthy amendment. So I'm just curious as to your feedback.
Mr. Chairman, Representative Duncan, I'll be glad to do that. I have it up, and I'll start going through it while you all are doing your discussion.
Okay, thank you. Representative McGuire, question?
Thank you, Mr. Chairman. And do we address you as Mr. Smith? Is that proper now? Or
right, I answer to a lot of things. Mr. Smith, Colonel Smith, hey you, whatever you want, sir.
Well, anyway, yeah, just based on your memory, in the last 8 years, so let's say, how many times has there been an issue with the licensing board that concerned one of your guard members, or maybe even somebody over at FE Warden, where the licensing board really was being obstinate or problematic, versus there was a question about where they went to school or a question about their degree? How many times was there a problem here in the state of Wyoming where, in your opinion, and this is simply an opinion, where the board really was probably not acting in the best interests of the military? Thank you.
Mr. Smith, if you'd like to answer that question, go ahead, in your opinion.
Mr. Chairman, you put me in a tough spot. We have enjoyed a great relationship with the boards. There have been several times, I would say less than a dozen times in the last 3 or 4 years that I'm aware of, where I have heard or been involved with trying to straighten out a military spouse's licensing with a particular board. Typically, it's an education thing or a misconstruing by the military spouse what the law said. In all honesty, I cannot say we've ever had a problem we weren't able to work with the boards and fix. What this bill would do, in my opinion, is make it more explicit and easier. One of the challenges I've heard several times from boards is they try very hard to follow the law. And when there's a situation that is broader that they didn't anticipate in the previous enactment in 2013, they struggle with trying to figure out how to support the military spouse while still complying with our existing statute. In my opinion, what the bill as written does is make that much easier and gives the boards more of an opportunity to take care of those various very fact-specific issues.
Okay. Other questions for Colonel Smith? Seeing none at this time. Just for a road map committee, I think I'm going to try to get all the public comment I can today. And then make sure everybody does have a chance to track through the amendment, see if there are any comments. And then depending on what the majority floor leader tells me the schedule is, we may have another meeting tomorrow at lunch, or see if we can still get this through the session this week, depending. So with that, if you still want to testify on this bill, we have 3 other people in the lobby. If you click on raise hand, I will pull you in. Next up will be Mr. Conklin. I know Mr. Ingalls in the lobby, but he has multiple profiles, so I'm trying to wait to figure out which one he wants me to pull him in on. But with that, please welcome Mr. Conklin. He should be showing up shortly. There he is. Welcome, Travis. The floor is yours as soon as you get your microphone on.
I think I'm there now. Thank you, Mr. Chairman.
Welcome.
All right, I'm going to move you down. So I'm the president of Wyoming Society of Professional Engineers. We had attended earlier committee meetings on this and expressed some concerns about this particular legislation, not the overall broader picture, but the impacts on our particular profession. Engineers are vested in responsibility for protecting the life, health, and safety of the public. And there is a model law that has been put together by National Council of Engineering Examiners and Society of Professional Engineers at the national level. And many states have adopted that, which is a good thing. But there are still states that have educational programs and similar processes that don't have the same rigor that the model law would require. And so those states have not adopted the model law. I believe that Wyoming has had 1 engineering license that has been issued through reciprocity in the last several years. And I imagine that person probably met the model law requirements. Our state board is very careful in making sure that people are meeting all of the background requirements. And unfortunately, there's a couple of gotchas with the way engineering, similar to probably trying to look at, say, doctors or attorneys operate. One of them is that in the state of Wyoming, a young engineer is allowed to take the professional engineer's exam anytime after they take the 8-hour and pass the engineering training exam. And then they have to have 4 years of documented professional experience working under a registered professional engineer. Theoretically, the way this law is written, 2 years in, a young EIT could take the PE, and if they happen to be married to somebody who is in the military, they can immediately go in and ask for a temporary license because they meet the requirements of that. So that's kind of a question, I guess. I don't know that that's true. But the idea here is that there are some little gotchas that are inherent to our industry. A lot of engineers do work from out of state in Wyoming. So for example, we'll regularly encounter engineers from Colorado, Montana, that will get a registration in the state of Wyoming. And theoretically, with this, an engineer in Montana could ask for this temporary license because they're married to someone who's in the military up in Montana, so they can do a project in Wyoming, even though they don't necessarily understand all the logistics of how we would do that in Wyoming. Typically, a young engineer, or not even a young engineer, but an engineer or surveyor coming into Wyoming is probably going to be working under or with other engineers before they start putting their stamp and seal and acting in responsible charge in the first few months. So this creates some issues with the life, health, and safety aspects of stuff. I would say that the temporary license with a requirement that they have the same education requirements, which match the national model law, would be reasonable. As this is written, this simply requires that you have the same number of years in your degree. So if you have a bachelor's degree in psychology and somehow had an engineering degree, you would theoretically be able to practice in Wyoming if you had passed the PE in a state that allowed that. I don't believe that that's out there, but it's not quite as cookie cutter as some of maybe the other professions are. I believe that engineering should actually be exempted. Land surveying is even more complex in Wyoming because it's a mess all over the country, anywhere between no education all the way up to a 4-year degree in land surveying. And so we're going to suddenly throw our state board under the bus and trying to sort their way through that. So with that, I would say that as engineers, we're out there trying to protect the health, safety, and life of the citizens of the state of Wyoming, and allowing others who don't live in the state to come in or work from outside the state under this statute would probably not be best served in protecting our citizens. Thank you, Mr. Chairman, for the opportunity to provide comments. I'd be happy to answer any questions.
Sure, thank you, Mr. Conklin. Representative Duncan, you're up first.
Thank you, Mr. Chairman. Mr. Conklin, thank you for testifying. I believe I have a couple questions. One is, I guess my concern is you said that you've only had one license since in a year. I just need clarification for that. And then the other part is, can you relate it to my scenario of realtors, where we have rules and you have to follow the licensing law, and that's clearly put into this bill so that anyone from out of state, they have to follow the Wyoming law in order to get their license. So, you know, the other part of that was the testimony we heard over the summer, and I believe you were there this fall. Correct me if I'm wrong, but some of your representatives at least were there. That majority of the people that are the military that would fall under this were CPAs possible realtors, teachers, those were the people coming, not engineers. So help me understand some of that.
Mr. Conklin, if you could extrapolate a bit.
Thank you. Good question. The one license, that's from the licensing board, and I don't recall if that's the last year or in the last several years that one license was granted to somebody who was a military spouse. So I'm sorry, I can't directly answer that. Shannon Stanfield probably would be a better person to do that. Relating to the education, there is a struck out portion of Senate File 18 that basically the verbiage that struck out there relating to education provides for what we're talking about here, in that engineering education is not it's a little bit more than just having the degree and having a license from another state, because not all the states are following the model law. The state of Montana has engineering technology schools that are not engineering schools. So those schools teach how to work on a project with a professional engineer, and they were put together under the National Council of Engineers Examiners. And the curriculum is established to be a hands-on, boots-on-the-ground type of job, not necessarily the professional in charge. It's sort of the equivalent, I would say, of, say, a doctor and a PA. And I have friends who are both, and I respect them both for what they do. But at the end of the day, there's somebody who's standing there who's got the science and medical background of the equivalent of a PhD. We're not obviously quite that far up there, but it's a little different standard. And so Montana has that. If you get that degree, Wyoming has an allowance to allow you to get additional education to become a professional engineer. So we're not trying to preclude those people. We just want to make sure they have the same level of education that the people who currently are in that practice have. Does that answer the question?
Representative Duncan generally believes you gave it a good attempt. Other questions for Mr. Conklin? Representative McGuire.
Thank you, Mr. Chairman. Two questions. First, Mr. Conklin, I myself hold two different professional Wyoming issued licenses. And one of the arguments that we always hear is that these professional licensing boards are trying to protect turf. And I'm just curious, in your opinion, has your board ever denied licensure just in a manner to protect turf, so to speak?
Mr. Conklin, I'm not sure you want to answer that in the negative, but just in case, go ahead.
Well, I wouldn't answer in the negative, but I can give a quick example that would express how that has not held out as a negative. So my father was in school for 6 years and passed the EIT. At this point, it's been 40 or 50 years ago, but he didn't ever get a 4-year degree. Under the laws, when he passed the EIT and applied for his professional engineer's license, they required that you have an EIT, but they did not require a 4-year degree. You just had to have the equivalent education. He was licensed in the state of Wyoming for about 15 years. And I suspect that particular history has held through the state of Wyoming. They follow the law that's set out there to try to protect the people, and they try to make sure the laws are at a level that will achieve that. Thank you.
Okay. Second follow-up, Representative McGuire.
Thank you, Mr. Chairman, and that's a great segue. So with regard to the board as it exists right now, if someone does apply and for whatever reason they are denied, is there a means to appeal that decision and to have it reconsidered? Thank you, Mr. Chairman.
Thank you, Mr. Conklin.
Yes, thank you, Representative McGuire. I believe that there is, but I'm really not that knowledgeable about that element. Like I say, I think Shannon Stanfield would be able to address that more completely, but I'm reasonably certain there is a opportunity to go and actually meet with the board and try to petition for licensure.
Okay. Any more questions today for Mr. Conklin? Seeing none, thank you very much, Travis. I think what my plan is, committee, is going to check with the majority floor later this afternoon if there's a way to continue this discussion tomorrow over the lunch hour, and if the bill does then pass out of the committee with or without an amendment, we could hear it on a committee of the whole tomorrow and still get it through this week. I will check with LSO about publishing the amendment on the bill on the webpage to see if there are determined any questions or concerns on the amendment, and we will take some more public comment at our next hearing, hopefully tomorrow, but if not, we'll save it till March. We just ran out of time today based on the amount of talking this morning. So with that, let's recess. We'll keep this bill kind of in the ether for the time being. Hope to see you all tomorrow at the same time, but I'll get a meeting notice out one way or another by 3 o'clock. Mr. Smith, did you have any final comments while I have you? I saw you turn your camera back on. Okay. Oh, yeah.
No, we're good, sir. I'll wait till tomorrow, whenever it's back up.
Okay. I will try to get a meeting notice out either way. If you don't see one by 3 o'clock, we're not doing it. If you do see one by 3 o'clock, we are. With that, thank you, Ms. Creech, members of the committee. If you log back into